Here in New York with us, trial attorneys Mercedes Colwin and Misty Marris. Welcome both. It's always great to see both of you. I think there are a few issues here we should talk through. Number one, do either one of you think Trump has a case on defamation?
Yeah, I actually think he does in this case because the words really matter. So a lot of these cases that high-profile people bring in defamation are really, really difficult. They're hurdles. And that's because of this concept of what's called actual malice.
Right.
So that is a very hard in litigation that's hard to overcome. So a lot of them get thrown out at the very, very beginning of the case. I think this one has legs because the reality is he was not found liable for rape. The actual words used were liable for rape. So that alone is going to create an issue of fact that will likely bring this case into the courtroom.
A couple of things, Mercedes. Sure. Number one, we can put up what the jury did find Trump liable for. To Misty's point, not liable for rape against E. Jean Carroll. That was what was found. It was sexual abuse in that case, which he was liable for. And then later he was found, as you see on the bottom of your screen, liable for defamation. Brooke mentioned, I wonder how this affects it, Mercedes. The judge in that case actually took time to clarify, for lack of a better term, or talk over and over about how this would have been rape as commonly understood. And the law has since been changed in New York after this. Does that have any effect on the defamation case?
That's a really great point, Connell. And we know this judge very well. This is Judge Kaplan in the Southern District, who was very vocal about this particular case, and in particular, former President Trump. It is true that maybe they won't actually move the needle at all in the civil case, but it is certainly some way for ABC and George Stephanopoulos to say, well, maybe I minced the words a little bit, but I actually have some proof that what was held was by what the judge said, which was very clear that maybe the jury you couldn't prove the rape, but certainly what you did was close to rape. So there's definitely, it's exactly what Misty said. There's a lot of back and forth and a lot of analysis that will take place, and a parsing out of those words, which are so incredibly.
Now, my understanding of this, and I understand maybe it makes some people uncomfortable because it's graphic, obviously, to speak about something like this. We talk about what the former president did or was found liable for doing. The definition, and both of you are lawyers, so correct me, before the last couple of months of rape had to be vaginal penetration, I think was how it was defined in New York. That's correct?
Correct.
Now, they've changed that because the former president, again, as I understand it from reading through this lawsuit, was using his fingers with E. Jean Carroll. That's what he was alleged to have done. That would be rape now, Misty.
Yes.
Probably, or no?
Well, it could be, yes. I agree with you that the definition of what is rape has expanded. But that being said, with respect to this particular lawsuit, that's not going to be the relevant point.
Because when this occurred, it was different.
Right, because Mercedes made great points, but the words exactly are liable for rape. And I think what they're going to do is they're going to go back and look at George Stephanopoulos and ABC's coverage. And there's a May 10th interview of E. Jean Carroll where he explains and he asks her, what did you think when Trump was not found liable for rape? So there you have an acknowledgement of what the ruling actually said, what the jury actually found, and they're going to use that to say that this was knowing. He knew that he was not found liable for rape, but yet said it on TV anyway. Now,
it's a very, in a political time like this, in an election year, it's amazing in some ways, just as an observation, that a political candidate would file a lawsuit like this and bring up what he had been found liable for, which is obviously very, very serious, which he did. But do you agree with Misty, Mercedes, that essentially that he still might even all of that said, he might actually have a case here?
Oh, absolutely. Misty is very true. It really boils down to whether or not there's actual malice, whether there's a reckless disregard for the truth, and there's so much evidence that he wasn't found liable for rape. Where there might be some wiggle room, like we talked about just moments ago, is looking at Judge Kaplan's ruling and really focus on that. But with respect to going out and finding, former President Trump doesn't even have to look for an expert to say that he's been injured. These are libel per se types of cases. We've defended plenty of them for our clients, some of whom have been public figures like former President Trump. In those cases, you don't have to go out. If you're accused of a criminal act, you don't have to go out and get an expert to say that you've been injured. It is per se defamation. So exactly what Misty said, one, it'll probably survive a motion to dismiss. And two, when you look for whether he has to substantiate an expert to come forward and say he's been injured, he doesn't have to do that under the law.
These are high bar, as we know, in these defamation cases, especially with public figures involved. So it's interesting to hear both of you say that. Final point before we let you go, I'll let both of you weigh in on this. Over the last couple of days, is, speaking of President Trump, this bond that he's been unable to secure, $450 million plus, I guess you couldn't get anybody to underwrite it, essentially. Impressions about where this ends up?
Well, look, about $100 million is the maximum you're going to get an insurance company to underwrite, and he's offered to pay that. Right now, he is going to be able to argue before the appellate division, but I see this in the procedural kind of void, because on one hand, the AG can move forward with executing the judgment, which means potentially getting these properties and liquidating. But on the other hand, he has to have the bond in order to move forward with an appeal. Now, any attempt at taking these properties by the AG, there's going to be temporary restraining orders. There's going to be other legal processes. I imagine the appellate division, when they actually hear the merits of the argument, which is coming up, is going to give him some relief and say he can post a portion of the bond. That would be my guess.
And practicing in the same appellate division where former President Trump is, likely there might be some reprieve by the judges, because he will be hurt immensely if all those properties are seized. But as Misty said, there are a lot of procedural hurdles to actually get access to those buildings and those properties and actually take them over.
No, you're both terrific. These they're complicated topics and a lot to work through, so we appreciate it very much. We'll see you both soon.
Thank you.
Sounds great.
Misty and Mercedes with us.